Okay, I'm back. Did you miss me? I know you did. So I am going to talk about your witnesses. How do I make the clicker work? What? The bottom? Ha! I'm talking about witnesses. I'm not technologically savvy. Everyone should learn that. I'm talking about your witnesses and your expert testimony. So the first thing of all is that witnesses can make or break a case. Each one of your witnesses scores 10 points. And that can be the difference between winning and losing. We've had teams that have won a case by 1 point. So it's a really big deal for your witnesses to do the best that they can. And the first thing a witness has to do is learn their character. But learning their character doesn't just involve learning your own witness statement. So can somebody else tell me what a witness needs to know? Green shirt right here.
Every exhibit that's included in their statement and every other statement that has their name in it.
Okay, every exhibit that's included in the case, as well as every witness statement that mentions them. Now, a lot of times witnesses forget that, but you can get questions on cross-examination about what another witness in the case has said about you. And it's really important for you to be able to stay in character and answer those questions. But you don't ever want to testify to something in someone else's witness statement. So if you testify outside of your own witness statement, who can tell me what that is? Plaid shirt, blue. Not hearsay, but it could be considered hearsay because it's another person's statement. But there's a special rule for that. Camo? Yes, you guys are focusing on evidentiary exceptions. I'm focusing on something else. It's a rule of competition violation. Extrapolation. So unfair extrapolation is something that witnesses can fall into without knowing it. If you start testifying to something that's in someone else's statement or cannot be reasonably inferred from something in your statement, one of two things can happen. The other side can object, and an unfair extrapolation objection can actually get points deducted from your total score, which will lower the entire team's score, not just the witness's score. And it can be as high as 10 points. So that can be a big deal for your team. Also, if you testify to something that may possibly be inferred from your statement, if your attorneys can make that argument, but it's not in your statement directly, the other side can try to impeach you. And if you're impeached, that means that you are also going to lose points. Because all of your scoring judges are looking to see how well you can stay in character, how well you know the material, and how well you handle both direct examination and cross-examination. Being impeached can drop your score from a 10 to a 5. So it's really important that you avoid that or you know how to get around it. So somebody tell me how you can avoid being impeached. Is it anyone besides Camo? Okay, blue shirt in the back. Know your witness statement. That's right. You want to know your witness statement. Also, if you want to avoid being impeached, you can always make sure that the attorney is impeaching you correctly. Because a lot of times an attorney will try to impeach you, but they're not doing it right. So you can get around being impeached. So not only do you have to know the rules for the witnesses, but you need to know the rules of evidence and when an attorney can impeach you. Because if they're doing it wrong, you can actually make the attorney look bad. So that's really important. Another thing a witness has to do, and it's very crucial, we've seen it a lot. I actually coach our witnesses that we take to nationals. Sometimes your attorneys will get lost. They'll get frustrated, they'll get flustered, and they won't know exactly where they left off. It happens to everyone. It happens to me when I'm in trial. A good witness will say something that brings their attorney right back to where they need to be. Sometimes a witness will just keep talking until their attorney finds their feet. A lot of times that happens when the other side objects, then the attorney will just snap right back to it. So as a witness, you're going to really try to make sure that you're doing everything you can and to make sure that your attorney knows where you're going. So that means that you have to know what your attorney's looking for. It doesn't mean that you want to let your attorney write your entire testimony and then only say what they tell you to say, because I want you guys to put it in your own words. You'll never remember it if you don't. And so it's really important that you have a good relationship with the attorney that's examining you. And on cross-examination, the biggest flaw witnesses get into is they argue with the other attorney. When you're a witness, you have to be in character. And unfortunately, we have a lot of witnesses who like to be combative. That actually loses you points with Oklahoma scoring judges. You can protect yourself to an extent, but it's your attorney's job to object and protect you. So don't be too combative, especially if you're playing the role of the little old lady grandmother. You don't want to be cussing out other attorneys on the stand. It's not really going to work well for you. A special subset of witnesses are the expert witnesses. For those of you who have had cases before, you know what I'm talking about. For those of you who are new, in cases in Oklahoma, we always have what we call competing expert witnesses. They can be medical witnesses, they can be forensic witnesses, they can be psychological witnesses. But they always have some kind of specialized knowledge, which is what's required for an expert witness. Your experts have to get on the stand and embody the specific area of expertise they have, which is no small task. We give you a witness statement, and typically we give you some kind of information about the area of expertise. For our arson case, we actually had competing fire investigators, and you had to learn all about what caused a fire, what intensified a fire, and when certain things happened during a fire. When you get on the stand, you want to be that specific person. You want to be authoritative, and you want everyone to know that you know exactly what you're talking about. And that's very tricky to do. Expert witnesses have to walk a very fine line because they're the ones that most easily unfairly extrapolate. And the reason for that is because we have a lot of witnesses who like to do their own research outside of the case. That's perfectly fine. You're welcome to do that if it helps you build your character, but you cannot use that information in our trials. And if somebody catches you, you will lose points. So walk a very fine line there of knowing when to use something and when not to. And if you think you're going to use the information that you found that wasn't in our materials, then just don't do it. It's easier to do that than to do unfair extrapolation. Now, there are a couple things that witnesses tend to do that I want to tell you not to do. First of all, if you really are a drama kid and you love it and you want to have an accent, go for it. But don't lose your accent halfway through your testimony or on cross-examination. That's a problem we've seen in the past. We actually see it at nationals every year too. Kids come up with these amazing, crazy accents and then they get flustered on cross-examination and it's not there anymore. So you'll lose points with our scoring judges because one minute you sound like Colonel Sanders and the next you just sound like a regular kid. So be very careful of that. The other important thing for witnesses to know is that you do have to wear your courtroom attire just like everyone else. You can pick your courtroom attire to be suitable to you, but you also want to make sure that without costuming, you can't wear a costume. If you're a priest, you can't wear a collar, you can't wear a nun's habit, you can't do any of that stuff. But again, I'll go back to the example of my favorite, the grandmother. If you're playing a grandmother, you might not want to wear 5-inch spiked stiletto heels. That might not be the best choice for your character. And witnesses have to stay in character for the entire trial because the judges watch everything you do. You'll be sitting there and they'll focus on you. If you're slouching, if you're sleeping, if you're snoring, they'll know. And that can affect your scores because they've been watching you the entire time you've been in the courtroom. So always stay in character and always make sure you know what you're trying to get out of your testimony. Does anybody have questions about witnesses? Yes.
Say you were playing like a little grandma, would you want to be hunched over while you were sitting off to the side, or do you just want to sit straight?
If I were you, I would sit straight. You can be whoever you want to be. If part of your character is being hunched over, you can. But if it's not natural for you and you lose it halfway through, people are going to notice. So I want you to be as natural as possible. And the best way to do that, honestly, for witnesses, do what you want to do. Practice it. Practice it in front of a mirror. Practice it in front of your team. Practice it in front of people who know nothing about your case. And ask if they think you're believable, because they'll tell you. And if you're really nervous that first day, everyone gets really nervous. Even me, I still get nervous. Go into the courtroom early, sit in the witness's chair and practice. You'll be amazed at how much more comfortable you'll feel once you kind of know what your surroundings are. Other questions? Okay. That's it. Expert witnesses and witnesses, do a good job. I want to see some criers.